So I wish to thank Sergio also for having accepted the role of chairing this event. So nothing I think I have left out. So thanks to all of you. And Sergio, you have the floor and the helm of the boat.
Sergio, devi accendere il tuo audio.
Otherwise, the boat is floating alone with no one at the helm.
And he comes from Genoa. He is from Genoa. That's really dangerous. Sergio, you must switch the...
I don't know.
No, okay, Sergio.
No, it's fine.
Okay.
Now it's fine.
Fine. Go ahead.
There is somebody who's now treating my microphone. I don't know whom. Anyway, thank you to all of you, and thank you, of course, our both organization, Italian organization, of which I am very proud to be part of, AIA and CAM. From my point of view, I have just to say a few words on not only on the book, but on the attitude and the approach of the content of the book, which is, in my view, the same, which now is shared by the majority of the Italian scholar and by the majority of the Italian jurisprudence. I have to say that the way to arrive to this result was not so easy. And the approach is to recognize the maximum extent possible, but within certain limits on which we shall deal with, on the power of the will of the parties to control the relationship they have and also the dispute they may have in order to finalize a result which is consistent with the initial intent. The idea is that the freedom of the parties to control their relationship and their disputes is fully understood within the Italian system, contrary to what was on until 20 years ago. Now, I think that the best example of what I'm saying is a last decision of our Supreme Court, which I mentioned before, was the Ordinanza Cassazione 15/4/2021, number 9863, under which it was recognized not only fully the power of the parties to choose the arbitration and to avoid the possibility to start with an ordinary proceeding in Italy. But above all, the possibility to argue about the existence of such consent, the contrary of which has to be proven. Therefore, there is no need to have a specific signature and a specific proof of the consent. In other words, the consent is implied also if it is not clearly expressed by the parties. This means that the arbitration by reference to a model contract or to a different contract in which an arbitration clause is included is accepted and implied. And therefore, the proof of the contrary has to be upon the party who objects the existence of such intent. So the intent which favor the arbitration is implied and agreed as principle. And the exception is, on the contrary, to have the such expression or such intention derogate in order to introduce the action before the ordinary judge. So, intent and arbitration clause is accepted also by reference with any particular difficulties. And that is an important point on which in the past the Italian system was strongly against. The intent in such sense is presumed, and therefore any reference to model contract or whatever like is considered enough and sufficient. And no specific signature, no specific intent written is no more necessary, and full and complete intent is to be considered as settled principle in Italy. Another point is complete freedom to organize the contractual relationship and the rules to be utilized to determine the possible result of any disputes left to the parties. This is what Massimo indicate as one of the possible notion of law at the very beginning in paragraph 1.2, when he clearly indicate that the meaning of law, which is very important to have in mind during the study and the arbitration, is the fact that law is intended above all as a body of rules which in a given social system, whether in a state or not state, govern interpersonal relationship, prescribing behaviors and enforcing prescription through sanction. This is exactly what is now progressively part of the Italian system, and there is no doubt that the trend is clearly indicated. I think that is all for the time being, and maybe I further intervene during our discussion, and then under the program we have, I have to start our discussion.
Well, Lucy Reed should have the floor now.
Excuse me, it's true. So, but Lucy is to be introduced by Stefano. Is it true?
I would give, let's say, for granted that they all know. They have the program. I introduced them all at the beginning, just not to take much of the time, Sergio. So I hope that Lucy and the other friends would not mind if we go directly to the debate.
I don't mind. I don't mind at all. Thank you for having me all the way virtually from Rhode Island in the United States. And it's, of course, I'd rather be in Italy, and I love listening to these accents because sadly, I don't speak Italian. And that is why, as I wrote in the foreword to Massimo's book, the only use that I ever had for his earlier Commentario Breve that he wrote with Claudio Consolo and Luca Radicati was to prop up my computer monitor in my office at the National University of Singapore. That's true. It's true that that's how I use the commentario. And it's true that I actually admitted it in the foreword to this new book. It's rather cheeky, I know, but Massimo and I are good friends. We go back a long way to Freshfields, and we've co-conspired on many cheeky things. I do speak English, and I'm well read in English literature. So I'm very embarrassed to say that Massimo had to point out to me in the footnote to the announcement for this webinar that the title, Italy as an Arbitration Seat, Not Such a Bad Place to Hang About In, is a reference to Unconditional Surrender, which is the last book in the Sword of Honor trilogy by the great English author Evelyn Waugh. Now, according to Massimo, a character in that book says that Bari, which is where Massimo is from, is not such a bad place to hang about in. Well, I can neither confirm nor deny that because Unconditional Surrender is not on my shelf. I don't know where it went, but I will engage in some literary one-upsmanship with Massimo and say that this book, the new book, is definitely not a handful of dust. And I have a scoop for you. The book is a must read for any serious international arbitration practitioner. And to get less cheeky and more serious myself, why do I say this? I say it because, as I wrote in the foreword, the book contains everything one might need to know about the impact of Italian law on the resolution of cross-border disputes by arbitration, either because the seat is Italy or the assistance of the Italian courts is sought for interim measures or enforcement, or because the dispute arises under an Italian investment treaty. Massimo, it's a long book, and Massimo covers and integrates some 1,000 court judgments, the main Italian treatises, and hundreds of legal articles, integrating those with international arbitration practice. He examines whether and how Italian law conforms to international norms or instead requires adaptation to those norms to comply with mandatory Italian legal rules and principles, which are not going to be known to non-Italian practitioners and arbitrators like myself. I would recommend taking a quick look at the table of contents because it shows the value of the book. It foreshadows a comprehensive but user-friendly tour, if you will, through the Italian international arbitration landscape. Chapter 1 covers international arbitration and Italian law. Chapter 2, arbitration and the Italian courts. Chapters 3 through 9, the conduct of international arbitration if seated in Italy or where the assistance of Italian courts is necessary, from the agreement all the way through to the award. Chapters 10 and 11 focus on challenges to the award and recognition and enforcement of foreign awards. And chapter 12 finally starts a dive into investment law and investment arbitration. Now, I'm willing to predict that the audience of this book will be wide. First, arbitration counsel with cases seated in Italy or involving Italian parties or otherwise connected to your legal system. Second, arbitrators and administering institutions in Italian seated cases. Third, judges, especially judges, of course, at the arena of enforcement of arbitration agreements and awards. And finally, academics, particularly, probably some are on this webinar, particularly those of you who are wrestling with investment treaty arbitration in the European Union right now. What I really like I read a lot of books, I get a lot of books, but what I really like about this book is that it's more than just a guide to Italian international arbitration law for foreigners or for Italians who have non-Italian speaking clients in international arbitration. That's because, as Massimo clearly sets out in the book, Italian arbitration law, it can be illuminating to non-Italian lawyers, whether common lawyers like me or civil lawyers, because it expressly regulates certain issues that are left to the discretion of arbitrators and judges in other places. For example, the participation of necessary third parties in arbitration, which is going to be discussed today, tribunal constitution with multi-party arbitrations, and remedies that are available to third parties affected by an award. Now, I thought about that. I thought about this a lot when I wrote the foreword. Here's what I thought. I said, if I were asked by a colleague who does not have, and likely never will have, an Italian-connected international arbitration, why she should read this book, and Massimo, I'll make a pitch, buy this book, I would say this: learning how Italian law identifies and resolves recurring international arbitration issues, whether in ways familiar to you or not, whether in ways you agree with or not, will expand your understanding of your own jurisdiction and your own practice and the issues. And I would say to a friend, trust me, you will be getting painless comparative law lessons. And I would add that you will be getting painless theory lessons, because Massimo truly elegantly, I think, builds a framework in this book of theory, starting right in chapter 1, where he addresses notions of Italian law and then builds notions of arbitration and then notions of international law. And later in the book, you'll find some original thinking on what we all recognize as very stubborn questions. For example, conflicts between party autonomy and state sovereignty, and the potential role of modern human rights law and EU law and insolvency law in arbitration. Now, I don't want to sound like I'm exaggerating the theoretical elements of the book at the expense of the practical. We all know that Massimo has played many roles in his career, and he produced this book solidly from the perspectives of practitioner, arbitrator, and professor. It's just that I find myself thinking more and more that I find it a mistake to think that theory is useful only for academics and practice only for practitioners, because after, 45 years at this, I find that the best advocates and arbitrators welcome knowing not just the rules to follow, but the reasons for the rules. Now, next up will be Massimo's 2022 Hague Academy lectures on the powers in international arbitration. And I'm going to end on a cheeky note again. In international arbitration in Italy, I'll show it one more time. Massimo saved his last acknowledgement for his life partner, Giuliano, who, and I quote, kept grumpily telling Massimo that no book on earth could ever justify missing things like beloved concerts and walks in the Dolomites. Well, Giuliano, if you're listening, I'm telling you right now that the Hague lectures will be worse than this book. So text me, just text me if you need some company. And maybe we can search for the fictional Castello Crouchback in Sant'Agostino delle Rocce, memorialized in Men at Arms, the first book of Evelyn Waugh's Sword of Honor trilogy. I'll send you my personal email, Giuliano. But to end on a serious note, congratulations, Massimo. I'm looking at you on my screen for the achievement, and thank you for inviting me to introduce the book, however briefly, to this audience. And I look forward to the learned discussion to follow.
Thank you.
Thank you very much, Lucy. Now we have the intervention by Maria Beatrice. Are you introducing? No.
No, we can skip the introduction, Sergio, and we can start now with the discussion with the three discussants. And my role is just to, after thanking, of course, Lucy for what she said, I'm still read, just introduce the topics. It is not proper and elegant for the author of the book to speak too much about the book. And the first topic is for me very important. And the person that will address it is Eduardo Silva Romero. The first topic has to do with the certain confusion which unfortunately is still around, and not only in Italy, but sometimes often also in Italy, about what international arbitration means, because it may mean different things. And if we do not have a clear idea of what it may be, then conversation and debate may be misleading. And this may have practical consequences, because it may lead to situations where counsel, members of arbitral tribunals speak a different language and do not share the same approach, misunderstand each other, and this may create an uneven playing field, which may create problems also in terms of due process. But I leave to Eduardo, because Eduardo is supposed to test these 7 different notions of international arbitration I was trying to propose.
Thank you, Massimo. And first of all, congratulations on this wonderful book, which I started reading with a lot of pressure. I confess I haven't finished, but I have advanced, and I'll finish it hopefully very soon. My first point is that we all know that Professor Benedettelli is an intellectual powerhouse. Every time we listen to his reasoning, the way he explains his position, it's always a pleasure to try to get to the ideas that he has to convey. And what I discovered analyzing the first 15 pages of his book is Massimo's intellectual honesty, because he says at the very beginning of his book that he cannot explore the different issues of arbitration law in Italy without being honest about some basic notions that are fundamental to enter into the analysis of the different arbitral issues. And you will see in the book that he considers that it is essential, fundamental, to explore 3 notions before entering into the technical aspects of arbitration law in Italy. One point that was already mentioned by our president is the notion of law. The second notion is the notion of arbitration. And the third notion, which was just mentioned by Massimo, is the notion of international arbitration. And in the paragraphs about these 3 notions, you will discover sometimes between the lines, you may discover Massimo's philosophy of law and Massimo's philosophy of arbitration. And let me try to make a few observations on Massimo's philosophy under these 3 basic items. If we start with the notion of law, I noticed that there are 2 ideas which seem to be very important for Massimo, and which are very relevant for the developments in the book later. The first notion, or the first element, is that the law is a system. They're stating that perhaps Massimo has been influenced a bit by Santi Romano. We all were influenced at some point by Santi Romano, I must confess. But obviously, conceiving the law as a system, as we know, has many consequences when we come to study arbitration in detail. And the second point about the law, which I found interesting, is Massimo's insistence that the law is something that should be enforceable. Enforcement is for Massimo an essential element of the law. I didn't find any footnote to Kelsen that perhaps Massimo suffered from readings of Kelsen, as we all did. I prefer Santi Romano, if I may say. But for Massimo, the law is a system, and the law should be enforceable, and this has consequences in arbitration law. What about arbitration? Massimo, in a very transparent, that's the word we use in our world, in a very transparent manner, tells us what is his notion of arbitration. And we will see that some of the elements of his definition of law appear here. And I will stop to read the notion of arbitration that Massimo proposes, because obviously that notion enlightens the rest of the book. He says, in arbitration, the parties agree that their dispute must be settled by adjudication. So adjudication is a key term in the definition of arbitration by Massimo. And he adds, adjudication means that the dispute is settled first by a body which is independent and impartial as regards the disputing parties. Second, on the basis of a syllogism where rules are applied to facts. Third, at the end of adversarial proceedings in the context of which the disputing parties are given an equal and fair opportunity to be heard. Fourth, through a reasoned decision, which 5 has or may acquire res judicata effects, and 6 may be titled for enforcement actions in cases of non-spontaneous compliance. The point that interested me the most in that definition is point number 2, the idea that in arbitration, arbitrators apply a syllogism, meaning the law to the facts. And that is important because one can perceive in the philosophy of Massimo that the duty of arbitrators to apply the law is of the essence in his theory. We all know that at times arbitration may be a process in which some arbitrators apply their notion of justice and at times do not apply the law that they should apply. So when Massimo underlines the importance of applying the law to the facts, I take it as a very personal and important statement that he's making through his definition of arbitration. And the last item in this jurisprudential section of his book is about international arbitration. And as Massimo explained, he goes through 7 different ways in which international arbitration can be perceived. And it is like a collage. And when one looks at the different 7 images together, one can get a sense of what international arbitration may really mean. He mentions, for instance, that international arbitration may be conceived as an entity which is linked with different legal systems. And so this is a way to perceive arbitration as a private international law animal. And with all the problems that we know that are solved or that we try to solve through private international law. He also conceives international arbitration as an arbitration governed by the so-called lex communis arbitralis. I read behind that expression what some call soft law or a spontaneous law, meaning all these provisions that the arbitration community creates to self-regulate. And Massimo mentions the ICC, the LCIA, all the institutions, the CAM, obviously UNCITRAL, the International Law Association, all these associations which propose practices, guidelines, rules, which to some extent govern the practice of arbitration worldwide. He goes and this is very interesting. He goes on to asking himself whether all these provisions that are being created spontaneously may be considered to be customs. But that's a very complex debate, as we know, that I'll leave for another time. Another standpoint that he takes to analyze international arbitration is international arbitration as an arbitration taking place within the international arbitration community. This is a notion that comes more from sociology, but the idea behind is that the ones defending that position are trying to find a society different from the societies in the different states where this proceeding applies. The idea behind is to find some freedom for the system against some constraints that could come from the different states. The fourth notion, as you will see in the book, is the one which is adopted here in France, the arbitral legal order, which you all know. It looks like our friend Massimo is not very convinced by the French theory of the arbitral legal order. I'm not either. And I certainly agree that an arbitration floating somewhere without the support of the states is not a realistic entity. We all know that sooner or later arbitration may need the support of the states, and this is something that Massimo explains very well in his book. He then goes on to analyzing really a different animal, which was already mentioned by Lucy, which is arbitration grounded on international law, and this is more investment arbitration. But this is this chapter is a short beauty, because in it Massimo advances some of his theoretical propositions regarding investment arbitration. For instance, he says that he doesn't believe the investor could be considered to be a subject of international law. He explains why. And he also says that this is a different animal because some arbitrators believe that they don't have only a duty towards the parties, which is to resolve the dispute, but they also have a duty towards the system or consistency of the system. And if I remember well, the reference he makes is to the case in Saipan against Bangladesh. This is a case was shared by Gabrielle Kaufman-Koller, who always makes a statement in her words that she has a duty towards the community of investors and the states. The sixth notion is arbitration based only on party autonomy. We also know, and this is Massimo's position, that an arbitration which is freely agreed and conducted by the parties with no intervention only happens if there is no problem. But if there is a problem, the states need to intervene. And in any event, party autonomy generally is limited by the law, and party autonomy in arbitration is in any event limited by the law itself. So we see that in the end, the theory of Massimo is between what some call subjectivism and objectivism. It's somewhere in the middle. Party autonomy is there, but party autonomy has limits, and those limits are objective in the law. And lastly, more technically, Massimo makes a distinction between domestic arbitration and international arbitration, landing all the discussion in the distinction that we found once in Italian law between domestic arbitration and international arbitration, and then stressing how in 2006 arbitration in Italy became a more monist regime. So this technical sense of international arbitration is not as important as it used to be. So Massimo, as a conclusion of my reading of these 15 pages that I need to read again because they're very rich, thank you for underscoring your philosophy, and we certainly need to have more than a coffee to tackle some of your opinions.
Thank you, Eduardo. And as I said before, knowing that you are an expert in philosophy, the real one, I'm really frightened by this reading of the first chapter. But I mean, philosophy is important also to deal with practical issues. And now I turn to Stavros, because one matter which is expressly regulated by Italian law, and it's not just theoretical, it's something that can happen. I'm currently involved in a case which has no connection with Italy, where this specific issue, arbitrating matters in connection with which there is the need of having all the parties involved, because this is required by the substance of the dispute. It is basically the exit of a partner from a non-incorporated partnership that under applicable law cannot be settled only vis-à-vis one of the partners, must be settled vis-à-vis all the members of the partnership. And unfortunately, only some had executed the arbitration agreement. As a matter of Italian law, this issue would have a clear answer under certain provisions which regulate what we call litis consortium necessarium in arbitration. In other jurisdictions, the problem is there. There is simply no rule. And I appreciate what Lucy said. One can take lessons from other laws and try to apply them, mutatis mutandis. And the reason why Stavros is here is because Stavros is one of the authorities in the field of international law, and he has been writing a lot about extension of arbitration agreements to non-signatory parties. And this is why when we discussed the topics, I thought this one would have been something interesting for him. And I'm really curious to see his reaction to these strange rules that we have in our Code of Civil Procedure. So please, Stavros.
Absolutely. Massimo, let me just begin by saying that I'm delighted to be part of this very special occasion to celebrate the publication of your remarkable book. And I want to thank you for this very kind invitation. As Massimo said, I will discuss the issue of non-signatory parties, third parties, and how Italian law deals with it. And here we are turning the focus from theories and philosophy, which I couldn't even address in the way that Eduardo, who is a true specialist, ever did. And we're turning more to doctrine, how Italian doctrine and Italian law addresses these matters. And here, Massimo's very strong threats as a doctrinal lawyer, not as a theoretical lawyer, but a lawyer that knows the doctrine of the law shines through. And we often, sometimes we like to discuss in arbitration about theories, philosophy, but it's a doctrine. It's the actual description and enunciation of the rules and the law that is more important, especially on a practical point. But having said that, I want to start from a more broader philosophical point, if I may, because the first thing about joinder and third parties, and as this discussion in Massimo's books is structured under the part of arbitration proceedings in Massimo's book. And this is understandably the case, because the question about whether a third party can be brought in arbitration proceedings between two other parties in Italy is treated as a procedural matter and is seen through the lens of the procedural powers of the tribunal. By contrast, the question about whether a third party can be brought in arbitration proceedings in common law jurisdictions, and in England, in the US in particular, is not so much a question of procedure, but is a question of arbitration agreements. And if you see the way that Gary's Bourne's treatise, for example, is structured, the question of non-signatory parties forms part of his chapter under arbitration agreement, not procedure. The same is in Mastil's book, for example, another very famous common law book on arbitration. For these books and common law approaches more generally, joining a third party or a non-signatory party in arbitration is primarily a substantive question of consent to arbitration or a matter of contractual interpretation. How can we infer consent of the third party to arbitration? Now, this gives insights into the more general understanding and treatment of arbitration in Italy and other European continental countries where arbitration is essentially a matter of procedure. This is why arbitration laws are typically structured as part of the national civil codes of procedure. This is the case in Italy, in Germany, in Austria, in Greece, and indeed in France, although France is also heavily influenced by conceptions of transnational arbitration law. By contrast, again, in common law jurisdiction, arbitration laws are separate, independent. We have the English Arbitration Act and we have the Federal Arbitration Act as separate autonomous arbitration laws, which are premised on the idea of arbitration almost exclusively as a contractual nature, akin more to a special form of contract law. Now, from this vantage point, it's not surprising to see that the main approach, the main ideas behind the treatment of third parties in Italy and Italian arbitration are very much influenced from their litigation and the concepts as the intervention of a necessary party that Massimo spoke about. Now, this procedural civil litigation approach is mainly driven by different considerations than you will find in common law. Considerations such as procedural efficiency, preservation of procedural resources. These are the overriding aims of this approach to third parties. Is not necessarily party autonomy and consent. And the relevant provisions of Article 816 of Italian Code of Civil Procedure allows intervention of a party even without the prior consent of the parties and arbitrators in two circumstances. The first is when the intervention aims only to support the position of one of the disputing parties. Here, the intervener is not allowed to file claims of himself, but it can participate in the procedure even without consent of the other parties. This is the case, for example, where a subcontractor, I can think, wants to participate in proceedings between an employer and a contractor to support the position of a contractor. Or the case of a guarantor that wants to intervene to support the position of the party for which the guarantor has provided the guarantee. Massimo can add more examples from practice. The second, and here comes to the question of necessary party, is the case where the party who intervenes or is joined by one of the existing parties is considered to be a necessary part. It's so closely intertwined with a dispute that the resolution of the dispute requires, as a matter of necessity, the involvement of that party. It is the case of litis consorte necessario, excuse my Italian. And examples here are those relating to rights in rem over assets which are common property of a plurality of subjects, obligations which can be performed only by a plurality of debtors. For example, comes to my mind, may co-owners that have agreed to sell a single item, or the true identity of a party to a sham contract, or the termination of a partnership, or any other kind of multi-party transactions, without the participation of all these parties forming necessary elements, part of the substantive dispute, the dispute cannot be resolved efficiently. Now, I should say that this idea of the requirement of a necessary party to be part of the procedure is something that is very common in, as I mentioned, in all European continental civil procedures. However, very few of them have attempted to transport this idea of a non-conceptual paradigm in arbitration. And here is what Italian arbitration law has done. Now, this is especially very difficult to conceive in common law jurisdictions, where the whole approach to third party, as I mentioned, is entirely consensual, implied consent, or consent through the principles of agency, representation, or the theories of non-party beneficiary. These are contractual legal constructs to bring in a third party. Even if the third party is considered to be necessary without implicit consent, the third party cannot participate. Now, allowing the participation of a third necessary party, even without full consent of all participants, may not necessarily be as bad as many in our common law friends might think, because an approach that looks into the realities of the commercial relationships, the substance of the dispute, in order to allow the participation of a third party through joinder in intervention, opens up the inquiry about third parties to the real aspects of the commercial dispute at hand. In approaches that are exclusively consensual, a third party who is party, even if it's directly implicated in the commercial side of the dispute, but has not executed the arbitration agreement, will have no access to arbitration. This party is shut down out from arbitration unless it has only signed the contract that includes the arbitration agreement. The Dalla case in the UK Supreme Court has confirmed that emphatically in the last 10 years. By contrast, the Italian approach that looks into the legal and financial interests of the parties and the non-parties in disputes and allows the participation of a third party who is not necessarily consented to participation in the disputes, allows for the protection of the real legal and financial interests in the dispute. That's a different understanding of arbitration. It's an understanding of arbitration as an open system that can communicate with the realities, the business, the actual commercial dispute. Some may consider this old-fashioned or a real heresy to the sacrosanct principle of consent. But as I said, others might consider this approach as there's something in there.
Yes, I guess someone connected now. Mr. Balashar, could you please shut down the microphone? Okay, good. Sorry, Stavros, we have to, yeah, sorry.
To close, I mean, maybe that's a sign for me to close, but I will close with this observation, with this thought, that you're right, Massimo, to observe, in commenting to this approach, that the main idea behind it is to safeguard the interest of those third parties whose rights may be affected by the adjudication of the pending dispute, and also to serve the fundamental right of access to justice, which might also be safeguarded in the context of the arbitration. I will stop here, and maybe we can have some time to further discuss at the end. But I think I made justice to your approach to the third parties and non-signatories.
Thank you, Stavros. You did indeed, and I was sure you were going to do that. And I'm sure we will have occasions also between the two of us to further discuss this topic. Marina Tavassi, as was mentioned before, is a former president of the Milan Court of Appeals, which means that she was heading the body that in Italy normally deals with recognition of foreign awards, and also is perhaps one of the main jurisdictions where challenges to awards rendered in Italy are heard. And so, I mean, Marina, it would be great to get from you an impression on some suggestions I make in the book, that the Italian legal system, as far as it concerns judicial assistance to arbitration, is not necessarily that bad as sometimes people think it is.
No, I can answer no. I believe that is exactly the contrary. It's a great pleasure to be in this group, to participate in the webinar, to celebrate your book, Massimo, and thank you so much for inviting me. Up until my previous appointment as a judge of the Court of Appeal for a long period, more than 15 years, and then of Counselor of the Italian Supreme Court, I dealt with arbitration awards. As judge of the appeal proceedings unfortunately, against the arbitral decision, in the very limited cases in which it is possible to appeal such awards, because the Italian legislator in the Civil Procedural Code establishes some very strict grounds for to challenge the arbitral awards. The topic of this conference has already been matter of study in your interesting book. And I think that I am very convinced in sharing the appreciation of all the speakers and the general opinion that this book represents a milestone for the knowledge of the problems of international arbitration in Italy, offering an in-depth analysis of every aspect that may arise in relation to these issues in our country and beyond. In fact, the approach of the discussion is much broader than a simple analysis of national rules and precedents, and is a source of reflection and a stimulus for discussion, not only for cases that may arise or in any case concern Italy, but in general Europe and the more international environment. As Lucy rightly said before, the book contains everything you need to know about the impact of Italian law on cross-border dispute resolution in international arbitration. But as a judge, until a few months ago, I must say that the analysis of the assumptions and the rules of arbitration, in conjunction with the indication of the correct modus operandi of the arbitrators contained in your book, also constitute the fundamental guideline for the judge who is called to ratify, execute, or to challenge an international or foreign arbitral award in Italy, or who has to deal with an opposition judgment against the execution of the ratification. My task today is to provide some information resulting from my experience as arbitration judge at the Court of Appeal of Milan and after, during my period at the Supreme Court. In my first period as counselor of the Court of Appeal of Milan, I can say that in Italy, Milan, as you said before, is the most important venue in general for corporate and commercial matters in relation to the economic relevance of its territory, and also because it has constantly managed to reduce the time of justice and to provide answers quickly. In any case, I had a privileged observatory in the 5 years I spent in the Supreme Court, when I was able to get know the work of all the Italian courts of appeal, also in this specific sector. My experience is linked to the appeals of the arbitral awards and to the proceedings of ratification and implementation of the decision of the arbiters. And in general, I can say that Italy is the right place to talk about arbitration. First, Italy has a great tradition in the forensic sector. I start from afar, having numerous ancient and glorious universities, and having always favored the forensic professions over other professions with respect to more technical discipline. It is not a coincidence that all these legal universities in the world are Italian. I remember Alma Mater Studiorum of Bologna and University of Pavia. On this old tradition, and in this context, civil litigation in the past grown enormously and also unfortunately grew the length of trial, but this is the past. In these last years, thanks to a series of reforms aimed at the specialization of judges and the speeding up of decisions, the disputes have been reduced and the length of trials has been significantly reduced. passing from 3, 4, 5 years to an average of less than 2 years for a first instance ordinary judgment, but much less for judgments concerning arbitration appeals, a maximum of 1 year for the judgment of invalidity, or few days or few months for the ratification and execution of the awards. And this is the date, I am referring to the data of the Milan Court of Appeal. More and more recent and upcoming civil trial reforms aim to establish an alternative resolution system for civil litigation and also to strengthen the use of the arbitration procedure. The Italian civil justice sector has been the subject of multiple reforms, especially in the most recent phase. The numerous legislative interventions, which concern both the demand and the offer of justice, were designed to reduce what has often been defined an excessive demand for justice, and in the same time improve the efficiency of our system and our courts. The changes involve both the procedures and the organizational aspect of the justice sector, with particular regard to the judicial geography. The most important provision in this regard was the law decree of 2014 in the general organization of our civil procedure, and the law number 40 of 2006 that Stefano has mentioned before, which contains a serious measure aimed at deflecting the abnormal pending barment using a voluntary devolution to arbitration, speeding up to civil process through some changes to the Code of Civil Procedure, and partially modifying the organization of the judicial system. But even in the recent days, the government has announced a series of reforms that should contain plans to rewrite the Civil Procedural Code, and the new law proposes to introduce an assisted negotiation agreement that is an arrangement aimed at the extrajudicial resolution of the dispute. It's based on the agreement by which the parties decide to honestly and loyally cooperate in order to find a friendly settlement of the dispute pending between them with the help of the lawyers. The measures launched by the government go in the right direction, since they allow also through a dejurisdictionalization, a speeding up of the procedure, and also a streamline of formalities in the recovery of credit. However, there remains the need to dissolve the structural norms that prevent the Italian justice from getting out of the situation of serious crisis in which it was in the past. But the more interesting intervention scheduled by our government is a decisive strengthening of the administrative staff support and a definitive and an important strengthening for the award, arbitral award. In my conclusion I can conclude that when the parties wanted to choose that the arbitration be based in Italy, they would make a fair and fully justified choice, not only for the solid regulatory framework of our law and of the regulatory bodies of the arbitration sector, but also for the competence of the courts, which are truly specialized, especially in large offices such as Milan, Rome, Naples, but also Turin, Bologna, Bari, Palermo. I can certainly conclude at this point, as the same Massimo considers in paragraph 1.94, thanking him for this appreciation, how such an agreement can reflect a group of different considerations, one of which may be its quality and the quality of the Italian courts. I hope that what I have reported so far will help to confirm this judgment. Just one point regarding the data of some appeal against arbitration awards. I can say that the cases of absence of these appeals towards arbitral awards are very, very rare. With regard to the grounds for appeal, I can say that regarding the most frequent grounds for invalidity that concern the violation of public policy, the data are very, very favorable for the awards. I can say that there have been 10 rejections and 2 acceptances in Milan in 15 years. For the other Court of Appeal, 20 rejections and 3 acceptances. For example, in 2018, 34 new proceedings were filed with the Milan Court of Appeal, of which just three were accepted, all the others rejected, therefore less than the 9%. In 2019, 62 new proceedings accepted, just 4. In 2020, 32 new proceedings accepted, 3. The most frequent grounds for invalidity is absolutely the violation of public policy, followed by the lack of motivation. In addition to the lack of motivation, the contradiction between the opinions, the motivation, and the operative part of the decision, and the contradiction of the award with respect to another decision or other award that is definitive and binding between the parties. These kind of appeals are quite frequent. I can conclude. I can say that Italy is the right place to talk about arbitration. Thank you.
Thank you, Marina. Very, very interesting, all the data about the low level of challenges which are granted by Italian Court of Appeals. Stefano, I think you...
Yes, I think we are running a little late. We might give the floor, if someone wishes to take the floor, to our audience in case they wish to pose pose a question. Then there will be someone to direct the question and to filter in some way. So you can use your chat. I'm sure that after 1.5 years of Zoom, we are quite all familiar with the device and the program. So I invite everybody. Otherwise, our speakers will have, of course, the chance to comment what they have heard. I have one general comment. If I look around jurisdictions, Massimo, I believe that there is no one that might be defined as heaven. They all have shades, and also the ones that they are very, let's say, very well sold. They all have shades, and I think there is not a perfect arbitration system around the world. Italy is not an exception, and I think that we have also some issues. We have to work hard. One hopefully will be done soon with the recognition to the arbitrators to issue interim measure. That is something that has been, personally, I believe, a little overestimated, but now we will probably have that. But other jurisdiction, it's not a competition, I think, among jurisdiction. But I think that also the ones that they are more advanced in some way, they have sometimes problems. And Italy, again, it's not an exception. And sometimes we also have bumps on the road. But as we say in Italy, one swallow doesn't make a summer. So sometimes we have, one step backward, but we are moving forward. That's my general comment. Is there anyone that wishes to take the floor? You are not forced to do it, but let's see whether.
For the time being, there are no questions in the chat, so I would kindly invite who has one to write it.
Very, very shy audience. And what about our speakers? Do you wish to? I don't want to start with the cold calling, inviting Pierre Tercier, for example, to say something, because I don't want to push him, but any others?
I don't know if you want to push, but you push.
I knew I could do it, Pierre. I knew I could do it.
No, it's great. Really, first, I would like also to congratulate Massimo. It's really a beautiful work. I would like also to congratulate all speakers. I would have, of course, a few questions, but probably they are not sufficiently philosophic for Eduardo, and probably a little bit too practical. But may I ask a question to Stavros? I was really interested in his difference he makes between the procedural side of the position taken by more civil law, and the more substantive way the common law takes. It seems to me there are still two problems, even in common law. The first question is whether the third party that is invited to participate had an opportunity to participate to the constitution of the tribunal and the first steps of the tribunal. The question seems to me clear that it is not possible for a tribunal to decide on the participation of a party if this party had not an opportunity to have its say in the substance. And once this is decided, then indeed you will go and see whether this party have consented. Do you understand my question? It was probably late and a bit complicated, but you see my point?
No, absolutely, I understand. And obviously, if you see under the ICC rules, for example, typically you need to file a claim about a non-signatory party at the very beginning to join. And as you remember there needs the first prima facie review by the Secretariat at the 6.4, if I'm not mistaken. And once this is confirmed, then the parties will have the opportunity to participate in the constitution of the tribunal, both signatory and non-signatory parties. And then the issue of whether indeed a non-signatory will be admitted is a different step that will be decided by the tribunal. That's all well and clear. In the concept of the forced, if you like, intervention of a necessary party under this civil procedural approach that Italian law takes, the issue of participation is resolved even at a later stage, if my understanding is correct from Massimo's book, and Massimo can correct me in that. They will be, if the third party is intervened after the participation of the constitution of the tribunal, then the tribunal will pause and will ask the third party to form the views that it may have on the constitution of the tribunal. And again, if I understand correctly from reading Massimo's book, the third party may have the opportunity even to appoint its own arbitrator, so to speak. This obviously has a practical consequence, which is that it may delay the process. The process may need to pause because the new arbitrator and the new party may need some more time to be briefed into the arbitration proceedings. But this is a price that someone has to pay for allowing a third party, which is considered to be necessary, in the arbitration proceedings. It is a procedural complication. I understand that, and I think the Italian procedure has taken the conscious decision to take this road, being able to address it even at a later stage at the expense of efficiency. Massimo, I may stand corrected on my understanding.
No, indeed, and actually this is one of the most difficult areas of Italian arbitration law, and I have to say this was the most difficult part to be written in the whole book, because the two issues that Pierre was pointing out, participation and constitution of the arbitral tribunal and consent, intermingle. The consent of the claimants when there is this consortium is implied in the very fact that they decided to go into arbitration. So by deciding that, they were accepting the intervention of the other missing party. However, the other missing party, if it is not bound by the arbitration agreement, has the right to intervene just to have a declaration that the arbitration should not go on. If it wants to stay in the arbitration, then it must be granted the opportunity to be involved in the constitution of the tribunal. This is one case of multi-party arbitration where Italian law has certain rules. If those rules do not work, then the arbitration cannot go on. This is the balance between, if you want, these conflicting requirements. But it's really a very difficult area. Even the law as it is written is not that clear, and there is room for different interpretations. I have to say another difficulty I had in writing this book was to deal with the Italian procedural law scholarship that is incredibly sophisticated. Sometimes it is over-sophisticated. And someone has to choose what is good scholarship to be kept and what is just overthinking about constructions who have no practical impact. This is one area where I think there are at least 20 or 30 different theories which have been proposed.
Any other questions? And thanks to Pierre for having started and probably also finished, because I don't see any others. So,
Stefano, may I make a very brief comment? It's more general comment. I mean, taking up on Marina's very helpful information about the approach of Italian laws. And the point I want to make is this. I was talking with our friend Mike Michaelrath the other day about Italy as a place of arbitration. And the observation that he made, and that's a brilliant point, is that today there's a wealth of talent and prominent arbitration practitioners that not live and practice in Italy. Not just Italians, but foreign arbitration practitioners. I think there's a wonderful opportunity for Italy now to advance its prominence, because it is a place where many clients, even if they want to be represented in an Italian arbitration, will look into Italian law firms that include both very good Italian and foreign practitioners to be represented. And so there's some exceptionally good developments and the ground for Italian arbitration to move forward. But obviously, for arbitration, with a seat in Italy to make real advances in the field of international arbitration, both Italians and friends of Italy, I hope you will excuse me including myself into it, should be all very honest about some challenges that have also come from previous courts, Italian courts in the previous years. That haven't made Italy justice to its reputation. That's why I was very encouraged to hear Marina's data about the limited intervention and inalignment of arbitration awards by Italian courts. And I think maybe this is the message that Italy needs to project more forcefully outside, that maybe what has happened in the past doesn't necessarily reflect the current practice. So that was the point I want to make.
Thank you, Stavros.
Positive one.
Apparently, there is a problem to pose questions through the chat. So I would invite, if first of all the moderator can allow people to take the floor, to switch on the microphone and the camera to those that wishes to take the floor and make the question directly, because apparently the filter doesn't function properly. So the chat and the raising hands. So I don't know whether it is possible to allow everybody
I see
at
there's
this time of the day.
From Martina Jacoboni, if she wants to.
Okay, but I would grant everybody at this time of the day to switch on the microphone and the camera if they wish. But the lady that you mentioned has the floor, I think, first.
Thank you. Thank you. So my question is about some exit arbitral proceedings that are in process right now between Italy and other EU member states. So under the light of the ACMEA judgment and the following agreement between the EU member states, what do you think are the odds that if any of these arbitral tribunal grants satisfaction to the foreign investor, the award will be executed in Italy, or if this will give rise to another Mikula case? I don't know if this is clear.
If I can, of course, I cannot take position on this, because this can easily be something in which I may be involved as counsel. However, I will be writing in the future about this. So if everyone who is interested in this topic, keep your ears open. I think one should make use of a theory that was developed many years ago by a French scholar of public international law called Georges Sell, who spoke about the so-called dédoublement fonctionnel, meaning that you can sometimes look at the same issue and the same behavior of an organ, looking at it from different points of view. It's a very simplified way of describing the theory. European law is at once based on international law, because it is the result of a treaty that creates an international organization, but it's also seen by itself as an autonomous legal system. And depending on which view you take, you may end up with different results. An Italian court, acting as if it were an organ of the European Union, may have difficulties in recognizing and enforcing that kind of award, because of a principle that European Union law set out very clearly in past cases. However, European law rests ultimately on the consent of the member states. Recent judgments of the German Constitutional Court show that there may be situations where there is a reaction by Supreme Courts to what European law is demanding to state courts. And whether this happens or not in connection with the enforcement of an exit award is a different issue. But I mean, it's a too delicate matter for anyone of this panel to take a clear position on, I guess.
Okay, thank you for your answer.
Any other question? I got one by WhatsApp. And is it time for a special section of the Court of Appeals for International Arbitration in Italy? I have my own answer, but I leave the floor to our speaker.
Stefano, this is Mike.
Okay, you made it.
Yeah, if I can, thank you. And hello to everybody, and thank you. So as I was for a little over 22 years, the head of litigation for, among other things, Nuovo Pignone, which is one of the largest Italian industrial companies, and I would say a big consumer of international arbitration here. And Stefano, what we've seen in those years, obviously, CAM has done marvelous things, and you guys are to be complimented. And I look at educators like Massimo, who've done really, truly tremendous things to build a community here. But I do feel that the courts, do hold back the growth here. And I asked that question, and I look at France, for example, which has had the support of its government to promote a very pro-arbitration law, and has developed a specialized section of the Court of Appeals for handling international arbitration. I look at Singapore, which Luciana knows very well, which the government has been incredibly supportive of arbitration. And then I look at Italy, and I wonder how many billions of dollars are lost each year of international arbitration work that goes to Geneva, to Paris, to London, to Singapore, because even Italian parties are concerned about the arbitration friendliness and the reputation. And a reputation is something that unfortunately takes many years to build for parties to become comfortable. And I just wonder if is this now a time for Italy to get on board with, I think, some of the robust reforms and support for international arbitration that we have seen taking place in many other countries.
I might start from Marina. I don't know, Marina, whether you have an opinion, having been, leading a court of appeal.
Yes, I think that could be a great solution to have some court of appeal specialized, as the Italian legislator has done for some other topics, such as intellectual property or antitrust trials. And I think that they have, the legislator must concentrate the competence, could concentrate the competence for the international arbitral award, or in general for arbitral award, in few courts, because it's not necessary that we have quite 30 courts that are competent regarding this kind of challenge towards arbitral awards. And I think that the specialization is a very good solution to have a rapid solution for the case, to have a consistency jurisprudence that is also predictable from the parties. And I think this point could be the good point also for abroad, to give for other, to give a representation of the Italian organization that could be very attractive for the other judiciary and for the international environment.
Thank you, Marina. Thank you, Marina. Any other?
Yes, we have two hands.
From Professor Giorgio Sacerdoti.
And then Jacopo Manosci.
Hello, everybody. It was very interesting. I have a question. It's a project constitute internazionale.
Giorgio non si sente benissimo.
There was a phone. There is a newly constituted Association of Lawyers in Milan, International Milan Lawyers Chamber, una camera internazionale come c'è la Camera Penale, and they have duly established 2 weeks ago in front of a notary public. The idea of launching in Milan a chamber of the court, let's call it, in English, operate launch in Paris, Amsterdam, has been attempted in Frankfurt. This sort of chamber, sezione, could also, of course, deal, but this would be the appeal to the recognition or support of international arbitral proceedings. What is your reaction? Was that successful? Will it be successful in Paris and Amsterdam, kind of competition to London post-Brexit? What?
Well, if I can answer quickly, I'm not a supporter of these courts that by simply using English as the language of the proceedings try to mimic arbitration and be competitive with the arbitration. I think the logic of many of these institutions is just that. If the parties want to resort to court jurisdiction, want to resort to litigation before courts, they can do that. And I don't think the language is the real issue there. We can, and it would need many years to have a generation of Italian judges able to master an entire set of proceedings in a foreign language. So personally, I'm not a supporter of these institutions. My information is that they have not been that successful where they have been created in terms of amount of cases referred to them. If the parties want arbitration, they go to arbitration. They don't need to go to something similar run by judges. But I mean, that's my personal opinion.
Shall we go to the other question by Jacopo Monoci-Landini?
Thank you, Maria Beatrice. If I may, because to be frank, I feel embarrassed among all these big names to try to make let's say, clever observation. But I'd like to pick up on Stavros' point and maybe also what Mike Kluwer wanted to mean. I totally agree that there's a great number of brilliant international arbitration practitioners in Italy now. There's a big offer. So when there is a big offer, probably also the rates, the costs of arbitration could be slightly decreased. So I wonder if there is an argument out there to, for example, for the Camera Arbitrale, to compete on costs of arbitration, given that there are many practitioners who can give a help, especially for small claims, because we know that the bigger institutions have problems when they have to deal with the small value claims, and they make reference, of course, to the Arbitral certificate that the Camera Arbitrale launched recently. So this is kind of provocation directed to Stefano to understand if a competition can be played on just on costs to give a high quality service on internet arbitration. Thank you.
I think that the answer would take too long. I honestly, I don't believe that competition has to be played on cost, because I think that cost, otherwise there would be no market for McDonald's. They would be leading the food industry, and because they have the lowest price. So I think that the competition among institutions, if we can say that we compete, because it's a very mild competition, I think, and very fair, I think is more against the poor quality arbitration. That's our competitors. That's our enemies. Not if they go to another institution that they do properly administer the case at maybe at lower rate than Milano, lower price than Milano, fine for me, provided that they do a good job. So I don't think that I'm not much worried about those competition, and I think that the history of the last 30 years of arbitral institution, at least in this country, speaks by itself. There was really nothing much around. I don't know, but Jacopo, I think we might have the chance to talk much better about it. Now I think we are really running late. I think that our chair Sergio Carbone had to leave, and I wish to thank him also in his absence. and Massimo. Maria Beatrice, of course, first as host, and I have nothing to say, simply thanking everybody. So Maria Beatrice and then Massimo, I think that for the very last.
Same for me, it was a great event. So thank you to all of you who stayed with us today. I was really happy. Massimo, your last word.
Well, my last word is again a word of thanks to the panelists, to you as hosts, and to those who decided to spend 1 hour and a half listening about arbitration. I have to thank Kluwer, because Kluwer was indirectly sponsoring this event. Those who registered can get the book for a discount. There is a code, I don't know of it, but CAM is running this, and I thank CAM for that as well. I have to mention two individuals who contributed in an important way to the book. Professor Zeno Crespi-Reghizzi was the co-author of Chapter 10 and Chapter 11 on challenges and recognition. Without his intervention, I would have not been able to finish the book. And a young colleague from our firm, Niccolò Minella, gave an important contribution to the last chapter on investment treaty arbitration. And I think it was necessary to remember their names. Last thing, stay tuned, because I will use LinkedIn. I mean, I belong to your generation, but still I have been forced to learn about these new techniques for having sort of pills in short videos on issues which I think are interesting as a matter of Italian arbitration law. I do believe that Italy has a lot to contribute to the international arbitration community. There are a lot of very good, talented lawyers. We should not be shy. We should impose ourselves in the world of international arbitration, and perhaps learning a bit about Italian arbitration law may be useful for everyone. And thank you again for being here this evening.
Thank you, Massimo. There is one hand raised by Giovanni Pagnacco. Giovanni, you want to say something?
Yes. I don't. Please do not hate me, because we are closing, and I don't want to make you prolong too much this very interesting meeting. I thank you very much. Everybody is a very high level as usual. The discussion as an end user, as an in-house counsel, probably my little opinion might be interesting for all of you. I mean, as an in-house for an EPC lump sum turnkey international contractor, we working mostly abroad. We have very small power of negotiation on arbitral clauses with our major clients, which are mostly placed abroad around the world. But with our subcontractors, we have this power, and I just want to testify that we are absolutely willing to promote and trying to promote the application of the reference to our country as a place, seat, jurisdiction for the arbitration. We trust in it. We have seen since I start practicing. I already seen with my eyes some very good progress with Stefano, with all of you. I'm in constant relationship, so I've been updated. I thank you a lot about that. And we will, just as an end user, willing to testify. I just willing to testify on behalf of my category that there is anything against trying to convince at least those that we can convince, which are in our kind of business, the subcontractors, to go for Italy, not only for vacation, but also because we believe is a very high level system and we are willing to promote it. So thank you very much and good luck to everybody.
Thank you, Giovanni. This was a very good conclusion, I guess. So really full of hope for our country. So thank you again, and see you hopefully in presence soon.
Thank you.
Thank you.
Thank you.